Joseph Aloba, the father of the late singer Ilerioluwa Aloba, popularly known as Mohbad, has filed an application before the Ikeja State High Court, seeking to quash the legal advice, decision, and recommendation made by the Director of Public Prosecutions in respect of the alleged murder case of Mohbad. Aloba is suing for himself and on behalf of the Aloba family. The respondents in the suit are the Lagos State Attorney General Lawal Pedro San and the Director of Public Prosecutions, Dr. Babajide Martins. In the suit marked ID/6197MJR/2025, dated March 12, 2025, and filed on March 13, 2025, Aloba, through his lawyer, Dr. Wahab Situ San, is praying the court for an order granting him leave to quash the legal advice, decision, and recommendation made by the Lagos State DPP in respect of the murder case of late singer Ilerioluwa Aloba, alias Mohbad. The motion ex parte application was based on 3 grounds for which the applicant Aloba said it lacked fair hearing under Section 36 of the 1999 Constitution of Nigeria. The other grounds are preemption of the coroner's inquest proceedings by the DPP's legal advice, which has yet to conclude sitting, and vital suspects mentioned and implicated in the coroner's proceedings have been allegedly freed by the DPP's legal advice. In an 18-paragraph affidavit in support of the motion ex parte, deposed to by Aloba, he stated that the death of his son Mohbad on September 11, 2023 was viewed as unnatural and suspicious, which led him to petition and demand an inquest in the cause of death. According to him, while the coroner proceedings have yet to be concluded by the coroner's court, on February 26, 2025, Magistrate Ejiro Kubehene at the Yaba Magistrate Court, acting on the legal advice of the respondents, AG and DPP, discharged and acquitted the 4 prime suspects: Abdulaziz Fashola, alias Naira Marley, Samson Balogun Eletu, aka Sam Larry, Owoduni Ibrahim, aka Prime Boy, and Pere Babatunde in the controversial death of Mohbad, who were released on an undated legal advice marked as Exhibit A. He further stated that what was shown to him and marked Exhibit B was a certified true copy of the proceedings of the Yaba Magistrate Court, which discharged the prime suspects based on the legal advice of the respondents. Aloba said the discharged and acquitted suspects by the respondents pursuant to their legal advice have been mentioned and implicated in the coroner's proceedings and have been summoned and are yet to appear and give evidence as to their role in the death of Mohbad. The police, through one ASP Mohammed Yusuf attached to the homicide section of the State Criminal Investigation Department, Panti, and the respondents, through their senior counsel, Mr. George, participated in the coroner's proceedings. The state CID Panti forwarded the case containing their investigation to the respondents without informing the coroner's court, and while both offices, particularly the respondents who are aware of the coroner's inquest, proceeded to issue legal advice, which prompted the magistrate court to discharge and acquit the prime suspects. That I know as a fact that the act or omission of the respondents is without due regard to the coroner's court, which constitutes an obstruction of the coroner in the exercise of his statutory duties. That I know as a fact that the respondent's failure to allow the coroner to conclude his proceedings and proceeded to issue the legal advice is preempting the outcome of the decision of the coroner and is done without jurisdiction and is null and void. That I know as a fact that the act or omission of the respondents issuing legal advice in respect of the matter upon which inquest is being conducted amounted to obstruction and interfering with the coroner's investigation and potentially influencing the outcome. That I know as a fact that the act or omission of the respondents issuing legal advice, which constituted an affront to the executive jurisdiction of the coroner, the power to conduct inquests into suspicious and unnatural death, is expected to run its course without external interference. That I know as a fact that the act or omission of the respondents, apart from being preemptive of the coroner's proceedings, undermines the integrity of the inquest and potentially compromises the outcome of the coroner's investigation. That I know as a fact that the act or omission of the respondent, while aware that the coroner's inquest is still pending, is to overreach the outcome of the coroner's inquest and is improper. The father of the late popular musician prayed the court for its intervention to get justice for the death of his son by acceding to his request. He added, "The applicant needs the intervention of this court to get justice for the death of his son. Otherwise, allowing the legal advice from the respondents to stay may automatically put an end to the seriousness of the coroner's court and its proceedings. That the grant of this application will not be prejudicial to the respondents. That I make this affidavit in good faith, believing the contents to be true and in accordance with the oath laws of Lagos State." Recording this is Musical Amy. Please do well to like, subscribe, and share. Thank you.